cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky. We're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need voices, the cities, the local town hall, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people, power back to the people.
Good morning and welcome back to W4Nevada Live. My name is Matthew Winterhawk and you're tuning in to continued coverage of Day 15, Coyote Springs LLC versus the state of Nevada. Thank you so much. Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine. All 17 counties, not just 2 in a sports book, right, Clark and Washoe? We love you. Not as much as you love yourself, but we do love you. So we're going to be getting back into this to see. I believe we have still Bonnie Rinaldi on the stand. I don't know exactly who will be examining. I believe we're at cross-examination yesterday. You have to follow up. But good morning and welcome back to W4Nevada Live. I'm Matthew Winterhawk, and thank you for tuning in. Like I said, all 17, not just 2 in a sports book.
All right. These official district report on the 13th, now session, animal market design.
Good morning, please be seated. Good morning. Reconvening for non-jury trials in Coyote Springs Investment LLC versus State of Nevada. Please state appearances of counsel, identify parties and party representatives who are present today.
Thank you, Your Honor. Mark Hutchison and Rob Hernquist and Todd Kennedy on behalf of CSI Investments LLC and related entities. And with us is Amelia Cargill, the general counsel for those entities. Thank you.
Good morning.
Good morning, Your Honor. Jeffrey Sylvester and Matthew Nealon of Sylvester and Flennick on behalf of the state of Nevada.
Good morning. The witness has retaken the stand and you realize that you're still under oath.
Yes.
Very well.
Thank you, Your Honor.
Proceed.
Morning, Mr. Naldi.
Good morning.
Recall when we spoke yesterday, we were looking at your opinion number 2, that the state engineer should have signed the final map. You recall that?
I do.
By the way, is that opinion related to your new opinion brought out on direct that the state engineer acted in bad faith?
Let me think about that. I don't know that it is. It was separate and apart from knowledge that from the documents that caused me to believe that he acted in bad faith.
Did you form that opinion while you were on the stand on direct?
No.
When did you form the opinion that the state engineer acted in bad faith?
On reviewing the series of actions that occurred on the map. Oh, I did form that opinion. That was related to the memo. I did form that opinion on the stand. That was related to the memo that I saw presented regarding a plan to deny the map, and several days later, there was the settlement agreement was entered into.
Yeah, I didn't see that opinion of bad faith in your expert report, and so that's the cause of my inquiry. Do you understand that?
Yes.
And so I believe your testimony is, just so the court has, is that you formed a new expert opinion on the stand during direct that the state engineer acted in bad faith, correct?
Correct.
You offer that to the same level of professional certainty that counsel got into you with you?
I certainly didn't have the opportunity to do any research around it, review any other documents, but just presented with those two facts, that is my opinion.
And so that I understand the scope of it, so that I may inquire on cross-examination. Your opinion is that the state engineer acted in bad faith because he denied CSI's final map in the one that was submitted in June 2019. Is that right?
No, my opinion is that the action in bad faith was having determined a few days prior that they had a plan to deny a map, and then several days later signing a settlement agreement stating that they were going to process the map in good faith.
So the foundation for your opinion that the state engineer acted in bad faith is solely the email that counsel showed you on direct?
That email and the fact that the settlement agreement was signed several days later.
Understood. What is your definition of bad faith?
Not being open and transparent, straightforward.
We were looking at some of the entries on your timeline, exhibit 553, Lindsay, if I can have 553. Mr. Rinaldi, I think for the record, your timeline in front of you doesn't have the 553 number on it, but I'll direct you to the Rinaldi base stamps, okay?
Thank you.
So I'm on 553005, Lindsay, please. And I asked you about 2017. Do you remember that? From yesterday?
What did you ask me about 2017?
Yes, I'm just directing your attention to the section of the timeline that has a entry for the year 2017. On Rinaldi 10. You recall my line of questioning yesterday where we began talking about correspondence between the Las Vegas Valley Water District and CSI concerning water availability in Coyote Spring Valley?
I do.
I showed you exhibit 3539. If I can have that letter on the screen, Lindsay, please. Just reorienting you or bringing you back to the line of questioning we were talking about. CSI is communicating, or excuse me, LVVWD is communicating directly with CSI. It's the April 2017 timeframe. I had a series of questions, a series of your answers about this particular correspondence. Does that reorient you in time from yesterday?
It does.
Okay. And if we scroll to 003 there, Lindsay, we talked about this closing paragraph where LVVWD is essentially saying, due to concerns about harming the environment and senior water rights, it's their opinion that water sourced from locations outside the Coyote Spring Valley will be necessary to support CSI's contemplated development at Coyote Springs. Do you remember that?
I do.
You hadn't seen that letter before I showed it to you on cross-examination yesterday, is that right?
I don't recall seeing it.
Okay. Lindsay, can I have 3543 and split screen? This is a letter from LVVWD to Amelia Cargill dated August 29, 2017. Do you see that?
I do.
As a previously admitted exhibit, and so let's talk about it a little bit. Again, Amelia Cargill, you understand, is associated with CSI?
I do.
And the subject line on page 1 there says long-term Coyote Spring Valley water supply. Do you see that?
I do.
Can you take a moment to review this and just let me know when you're done? If you need Lindsay to enlarge any sort of section of it, just let her know.
Thank you. I'm finished reading it.
Okay, have you seen this letter before?
No.
Paragraph 1 on page 1 says following up on our meeting. And then it lists the names of some people. And the last name there, the last line there says between our engineer Laura Jacobson and your engineer Doug Chen. Do you recognize the name Doug Chen?
No, I don't.
Okay. Paragraph 2 Says we previously met with you in March to discuss issues relating to the availability of a sustainable water resource in Coyote Spring Valley and its direct impact on CSI's proposed developments. You see that?
I do.
And paragraph 3, Lindsay. And I'll need the end of it on page 2 as well, please. Thank you, Lindsay. By the way, from your review of this document, do you understand that Mr. Chen is associated with CSI at this point?
I do.
Okay, so it says, following up on our March meeting and my letter, then it has a bunch of information. I'm mostly interested in the last sentence there that continues on to the next page. It says, to further clarify our position and to respond to Mr. Chen's email, it is the district's position that due to State Engineer Ruling 6255 and the data upon which the state engineer relied, a plan for development of non-Coyote Spring Valley source of water, together with an agreed upon mechanism to ensure its construction, must be in place before undertaking to develop further uses of water within Coyote Spring Valley. Do you see that?
I do.
And you hadn't seen this, so it's not in your timeline. Is that right?
Correct.
And this is again, the water purveyor, or the manager of CSI's water purveyor, telling CSI their Coyote Spring Valley permits can't support the contemplated development, right?
Correct.
Can take that down, Lindsay, and return to the timeline, exhibit 553, please. 553005. We're in the November 2017 timeframe now. And Mr. Knoll, do you have an entry there for November 2017 that says LVVWD requested opinion of state engineer regarding ability of CSI water rights to supply water and execution of subdivision maps? You recognize that prior to that entry in time are the two letters that we've just talked about, right?
I do.
Okay. So Lindsay, if we can now turn to 3548. Previously admitted exhibit. And yes, split screen, beautiful. This is the November 16, 2017 letter from LVVWD. Now it's addressed to whom?
Mr. Jason King, state engineer.
State engineer at the time, Nevada Division of Water Resources, right?
Correct.
And if we look at 001, the last sentence on 001. We go to the last portion of that sentence says, we are not convinced that Coyote Spring Valley groundwater can sustainably support the project given endangered species issues in the Muddy River and impacts to senior water rights. You see that?
I do.
That's consistent with the two letters that we just looked at where LVVWD is saying the same thing to CSI, right?
It is.
Okay. And Lindsay, if we can go to 002 and you can just enlarge the whole paragraph there. There's a second sentence. It says, while we have made our views regarding sustainability and impact of ruling 6255's findings clear to the developers. Do you understand from reviewing this document that developers is referring to CSI?
I do.
Right. We've made our views clear to CSI. And do you understand that these letters to mean, LVVWD believed CSI's permits in Coyote Spring Valley couldn't support residential development?
Not precisely. I believe that state engineers role to determine whether water rights exist or not, and the water can be used or not, and which is precisely why their fair and transparent management of those rights is so critical.
I think we can agree it is the state engineer's role to enforce permit terms,
Yes,
make the determination of water availability.
yes.
Part and parcel to that, though, is that the water purveyor is on the same page with state engineer. Wouldn't you agree?
Objection outside of the scope of this witness's expertise. She's not a water expert. She said that yesterday.
That's part of the line of questioning. Thank you, counsel, but she's offered an expert opinion now that the state engineer has acted in bad faith. I think we titled that cross. Thank you, Your Honor. So back to your answer, my question that preceded it. I simply asked, do you understand these letters to mean that the Las Vegas Valley Water District believed CSI's permits in Coyote Spring Valley could not support residential development?
Yes, and when combined with this letter, they are asking for clarification from the state engineer.
And you
Because
agree?
they're the state engineer's office is the one to make that determination.
I apologize for speaking over you. Are you done with your answer?
I am.
Okay. And you and I agreed yesterday on cross that a master plan developer won't begin construction until they have that assurance or certainty that water will be there once the homes are built.
Please repeat that.
Yeah, you and I agreed yesterday on cross that a master plan developer won't begin construction until they have that assurance or certainty that water will be there once the homes are built, right?
A master plan developer can't build a home until they have a single family lot. And then that single family lot isn't created until the state engineer signs off on a map saying that there is water availability.
And you agree.
And that's based, excuse me,
Sorry?
and that is based on a statement from a water purveyor that they can deliver the water.
Thank you for anticipating my next question. The map submitted to the state engineer prior to recordation comes with a will serve letter from the water purveyor, right?
If it's a single family residential lot map, yes.
So the developer won't construct infrastructure necessary to support the master plan community until they get that final map, which will come with a will serve, right?
Not precisely. There are typically a series of maps. The large lot or builder's lot maps require some construction of backbone infrastructure. And those maps are recorded with very limited water commitments, just usually 2 acre-feet per lot. But there is some infrastructure construction requirements related to those that will occur typically before a single family lot subdivision is recorded and before a single family dwelling could be constructed.
You have that binder from yesterday in front of you?
I do.
You can turn to the tab that says deed of deposition. And I'm on page 53 of your deposition, please.
For the record, I don't believe the deposition's been published, correct? What?
Can I ask the clerk to do that?
Yes. So
Thank you, Your Honor. It's okay to approach.
Yes.
Can I approach the witness, John?
Yes.
Preference of the court is that you use this version of the deposition rather than the one that's in front of you. So you can set that one to the side, please.
Again, I'm on your deposition at page 53. You with me?
And
I'm on line 20. The question in deposition was, okay, so you won't construct the infrastructure necessary until you get the final map, which will come with it a will serve, correct? That's your best testimony and your answer?
my answer was yes, but that is bringing the infrastructure to the single family lot. There's other backbone infrastructure that is typically created, constructed, designed prior to a single family lot when you have a master plan community.
Some infrastructure would be built, but certainly the master plan developer is not going to be building homes until they have some assurance or certainty that water is going to be there once the homes are built, right?
Again, they won't be building homes until they have a single family residential lot map recorded. And that isn't recorded until the state engineer signs off that there is water quantity available.
So the recorded map is what gives them the assurance and certainty that water will be there once the homes are built.
Yes,
So is your answer to my question, yes? You stated the master developer won't begin constructing homes until they have some level of assurance or certainty that the water will be there once the homes are built?
Objection asked and answered.
Overruled.
some level of assurance is different than absolute assurance or certainty. So they have some level of assurance throughout the process because they rely on the science and the processes set forth in the rules and regulations in the state of Nevada and in Clark County. So there's different levels of assurance as they get closer to being able to develop a single family home.
I'll try it in the negative. Do you think a master plan developer would construct homes before they had that certainty that water was going to be there after the homes were built?
Again, they
Objection,
can't,
objection again, Your Honor. Asked and answered. Overruled.
they can't construct a home until a single family lot is created. And that's not even quite accurate. They could create a single family home on a large lot.
What would be the source of water if they did that?
A well.
A well. They could, in fact, develop an entire community on well water, couldn't they?
That's conceivably possible, yes.
Would that have been consistent with CSI's development agreement?
Not necessarily inconsistent.
Do you know whether they submitted any sort of map or plan to develop their community on well water?
I have no knowledge of that.
We can go back, Lindsay, please, to 553. I'm on your timeline again, Mr. Rinaldi. You can set that deposition transcript aside. I'm at 553005 again. It's Rinaldi 10 for you, Ms. Rinaldi.
Thank you.
So in the 2017 timeframe, we've talked about the various letters that LVVWD is writing. One question I forgot to ask you, wouldn't you have wanted to have these letters prior to issuing your expert opinions in this case?
I did have the letters that are listed here.
The timeline reorients us in time to the exhibits that we just looked at, the LVVWD series of letters, April 2017, August 2017, right?
Correct.
Wouldn't you have wanted to review those letters prior to issuing your expert opinions in this case?
I wasn't aware that they existed.
I understand that your counsel never gave them to you, but would you have wanted to see them before you made your expert opinions in this case?
If I wasn't aware of them, I just wasn't aware of them. So how would I know I wanted to see them?
Well, you've seen them now, right?
I had.
Do they bear upon your opinions, for instance, that the state engineer acted in bad faith?
No, those letters were from the Las Vegas Valley Water District, who can't make a determination as to water who can't officially make a determination as to water quantity availability.
You agree that there's communication between the municipal water purveyor and the state engineer's office as it relates to the execution of subdivision maps, correct?
I do.
We established that along the continuum, the timeline that, in fact, as early as 2006, we looked at an exhibit that showed the state engineer office requesting such a letter from municipal water purveyor in order to execute a subdivision map, right?
Yes.
So if the municipal water purveyor is of the belief that water is not available, is that relevant to your opinions in this case?
Well, it is, and that's why they requested clarification from the state.
So is your answer no? You didn't need to see the April 2017 and August 2017 letters between LVBWD and CSI to formulate any of your opinions in this case?
From what I've read today, they don't change my opinions.
Not that they changed them, but certainly would have been information you wanted to see.
And that's asking me to look backward in a way that, I just don't know. I'd have to, if you'd asked me that question 4 years ago, I might have an answer, but seeing them today, it doesn't change my opinion, and I don't know if I would have wanted to see them or not.
Who selected the information that you reviewed in forming your expert opinions?
Most, the information came from the county record or from citation of things listed in the past litigation or the claims made in those filings.
Understood. There's an entry on your timeline. Lindsay, if you can highlight this, July 2018, not the tentative map, but the other one. It says state began public review process of water available. You wrote those words?
I did.
What does that mean to you?
That means to me that to me, it relates to some prior listings, so I'm going to read through those again.
Sure, take your time.
I believe it relates all the way back to the rulings 6254 and 55 made in January of 2014 that said there was insufficient groundwater and that the public review process was a follow-up step to those rulings.
Okay, so what was happening at that time, if you can recall?
I don't know.
Exhibit 3581, please, Lindsay. Previously admitted. The first page of this exhibit is an email from Jason King, who you understand to be the state engineer, correct?
Correct.
And it's to someone named Albert Sino III. Do you recognize that name?
I do.
How do you recognize that name?
I recognize that name as one of the owners of Coyote Springs.
And the email says, "Good morning, Albert. Just wanted to send you this link to the letter that was sent out this morning, stated June 14, 2018. See that?
I do.
And then in the hyperlink, there's a reference to the words public workshop. You see that?
I do.
Okay. If we turn the page to 002 there, you'll see a letter from the hyperlink, indicates June 14, 2018. You see that?
I do.
Have you seen this letter before?
No.
We're looking at the subject line of this letter. It says public workshop regarding existing water right use and groundwater pumping in the lower White River flow system. Do you see that?
I do.
By the way, if you hadn't seen this letter, how did you, or what information did you use to put that entry for July 2018 on your timeline?
I believe it came from the statements made in the filings, in the legal filings that were made.
Okay, the The first paragraph there. Oh, excuse me. Since you haven't seen this before, Lindsay, if we can get rid of the very first page and then just give Ms. Rinaldi a split screen of 2 and 3. It's a 3-page letter, so I'm not going to ask you to read it in detail, but if you can just peruse it, get an idea of what it's saying, and then look up when you're done, I'll ask you some questions about it. You have a sense from your review so far what's happening in this letter?
Yes, so far I'm just reading background.
Okay. Would you like to continue reading, or do you feel comfortable answering just a couple of questions on it?
I don't, depends on the questions.
Okay, so in the first paragraph, just says, please take notice, the Nevada State Engineer set an initial public workshop, and it gives a date, a location. I'm just gonna draw your attention to the next full sentence there. It says the purpose of this public workshop is to provide an overview of the status of groundwater use and recovery following the conclusion of State Engineer Order 1169 Aquifer Pumping Test. You understand that to be a reference to Order 1169 pump test that we previously discussed?
I do.
To address the feasibility of developing appropriated groundwater rights both within the carbonate and alluvial aquifers within the lower right river flow system. And we've talked about that previously, right? The carbonate rock aquifer is the source of water for CSI's permits, right?
You stated that. I don't know that precisely.
Okay. And that's within the lower White River flow system that connects the multiple basins and the Muddy River. We previously talked about that.
We did talk about it.
And to take public comment on proposed management options. Do you see that?
I do.
So the state engineer is gathering water right holders and saying, let's come up with some management options for the lower White River flow system, right?
I'm just reading these words. I'd take public comment on proposed management options. I don't know that he's seeking public input on those options. He may just be asking for their comment on options he's developed. I really don't know who the source of the options, of the proposed options would be.
Okay, and Lindsay, if we can go to 003 then. And you can actually just enlarge the whole page. Maybe that's not gonna work. We'll go paragraph by paragraph. First full paragraph then. When you read this just a moment ago, did you understand this? I think you said this is providing some background or history to what was the purpose of the public workshop process.
That's my understanding.
Okay, it says during the Order 1169 aquifer pumping test, and it gives information about how much acre feet per year of permitted rights were pumped. Do you see that?
Yes.
And then it says that the results of the 2-year test demonstrate that pumping from the LWRFS aquifer caused unprecedented declines in groundwater levels and flows in 2 springs, 2 high altitude springs that are considered to be early warning indicator springs for the overall condition of the Muddy River. And we previously established that there are vested rights on the Muddy River, correct?
Yes,
And that the endangered Moapa dace lives in the springs that feed the Muddy River, correct?
yes,
Okay. And now the state engineer is recounting the results of the pump test that showed unprecedented declines in those water levels, right?
that's what it says.
Okay. Says, give some more information about the springs, where the dace live. And then do you see in there the reference to ruling 6254 and 6255?
I do.
It says, based on these findings on January 29, 2014, the state engineer issued these rulings, and then it's a series that includes 6254 and 6255. The reason I bring those to your attention is because they appear on your timeline,
Yes,
and you indicated on cross that you reviewed those rulings before forming your expert opinions, right?
yes.
The next full paragraph there, Lindsay, please. Based upon model results and observations made during the carbonate aquifer pumping test, it is asserted by some study participants that pumping at the order 1169 rate could result in both of the high altitude springs that we just mentioned going dry in 3 years or less. You know what would happen to statutory permitted rights if the springs referenced here went dry?
I don't actually know.
In the 5 years since the completion of the aquifer pumping tests, monitoring of pumpage and water levels has continued. And the additional data is providing the state engineer a better understanding of the amount of groundwater pumping that may be sustainable in the LWRFS. I can't remember if I asked you this or not. You know that the Coyote Spring Valley is within the LWRFS?
I concluded that based on how many times it's referenced, and
And the research that you did.
that's correct.
And the next full paragraph there, Lindsay, third on the page. Yep. Give some information here that I think is relevant. There exists over 50,000 acre feet of groundwater appropriations in the LWRFS dating as far back as 1919. And it tells us that pumping 10,200 acre feet of these rights from carbonate wells during the test yielded an unacceptable loss in spring flow and aquifer storage within the LWRFS. Do you see that?
I do.
And we can skip the next sentence, but the last sentence of that paragraph says, this leads the state engineer to believe that only a small portion of the permitted water rights in the LWRFS may be fully developed without negatively affecting the endangered Moapa dace and its habitat or the senior decreed rights on the Muddy River. I'm not sure if I asked you this exact question, but do you know what would happen to the permitted water rights in the LWRFS if there were negative effects to the endangered Moapa dace and its habitat?
I don't precisely know.
Or the senior decreed rights on the Muddy River?
I don't precisely know.
Okay, so the last full paragraph is, all of that leads us to this. The purpose of the public workshop process is to apprise the water right holders and other stakeholders in the LWRFS of the serious concerns related to the anticipated effects of full development of existing rights in the basins. You know if those existing rights in the basins would include CSI's water permits?
I would, yes, they would.
The public workshop will also provide water right holders an update on the current status of the water resources in the LWRFS in the 5 years since the completion of the aquifer pumping test, address concerns relating to the location and effects of groundwater pumping, and here, the opportunity to comment on how best to proceed in developing the water resources in the LWRFS. See that?
I do.
Does that give you some more context for what we read on page 1 as to what the state engineer was attempting to do with the public workshop process?
It doesn't give me any further information, no.
Do you understand what this is saying?
I do. They have the opportunity to comment. It doesn't sound like they have the opportunity to propose how to best proceed, but opportunity to comment.
On the next page, Lindsay, there's a reference in the middle of the first full paragraph that says a copy of the planned presentation for the public workshop will be made available online. Do you see that?
I see it.
Did you look at that planned presentation before you made your expert opinions in this case?
I did not.
Okay. Let's take a look at that presentation, please, Lindsay. Exhibit 3593. You see exhibit 3593 previously admitted on your screen.
I do.
See on the first page, it indicates the title, water use in the lower right river flow system, Jason King, state engineer, and then it gives a date,
I do.
July 24, 2018. That corresponds to your timeline entry that a public review process had begun.
It does.
And so if we, did I ask you, have you seen this before?
I don't recall you asking me that, and no, I haven't seen it.
Haven't seen. 005, please, Lindsay. We can go single screen on this one. The title of the slide 005 is Why Are We Here? Greater than 40,000 acre feet in committed groundwater rights in the LWRFS. Do you understand what that's saying?
I do.
What is it saying?
There's more than 40,000 acre feet of water rights committed in the White River, in the system.
Lower White River flow system?
Yes.
The 2-year carbon and aquifer test of 10,200 acre feet annually caused unprecedented, then it gives 2 bullet points, decline in the high altitude springs and decline in groundwater levels. The next page, Lindsay, 006. The last bullet point says, based on the aquifer test, subsequent data collection, and current development pressures, it is critical that a management strategy be implemented. Do you see that?
I do.
Do you understand what that's saying?
The state engineer feels it's important to have a management strategy.
You have some understanding that current development pressures would be a reference to Coyote Springs' proposed residential development?
You can see how it could be.
Do you know of any other master plan communities, proposed developments within the LWRFS as of July 2018?
I'm really not in a position to know.
The answer is no,
I don't know.
you don't. 55 then, Lindsay, please. It says, what is our goal? Maximize beneficial use of water resources on the one hand and protect senior water rights on the other hand. You know what protect senior water rights means?
Because I'm not a water rights expert, I don't know the full meaning of those words.
Do you have a limited understanding?
Just a generic understanding, it means to protect water rights that are senior, more important, more committed than anything that's occurred since.
I think we established on your first day of cross that you did have the understanding vested rights, for instance, in a surface water source are senior to permitted rights under the statutory scheme, right?
Yes, very basically, yes.
And then the other side of the seesaw says maximize beneficial use of water resources. Do you know what that means?
Yeah, not in the fullest definition because I'm not a water rights expert. Just a generic understanding of what those words mean.
What's your limited understanding?
That this One of the state's goals is to maximize the use of those water resources.
Right, the state engineer is not in a position to hoard water resources, right?
Correct?
It's the goal of the state of Nevada and the state engineer's office to maximize the use of the water, right?
That's what's stated here, yes.
If we turn to 56, please, Lindsay. The title of the slide is options. You agree with me that the state engineer has identified what has previously been characterized as serious concerns, right?
Yes,
And then we just saw the slide that said, we've got to do these two things. We've got to balance maximizing beneficial use while we're trying to protect senior rights, correct?
correct?
Okay, now this slide is giving us some options. Says use existing expertise and give some information about hydrologic review team that we've discussed previously in this trial. Establish a working group consisting of HRT members. Establish groundwater pumping thresholds and monitoring the springs. Next slide, Lindsay. Identify other sources of water. For instance, an interbasin transfer of other groundwater or surface water. Do you understand what that bullet point means?
Not fully.
That one of the options could be to bring water from outside the LWRFS for a proposed development?
That's been mentioned in the letters from the water district.
Did you understand that CSI has significant water rights and that we've referred to in this trial as the Tuppy Ranch water outside the LWRFS?
I have no knowledge of that.
That wasn't information provided to you before forming your expert opinions.
It was not.
Continuing on with the options, it says support stakeholder developed groundwater management plan. Do you know what that means?
No, I really don't. I don't know what that is.
Or reduce active groundwater rights via curtailment, relinquishments, cancellation, or forfeiture. You see that?
I do.
Do you know what that's a reference to?
No, I don't.
Do you know that the state engineer has limited statutory tools available to him or her when their water in a particular area or basin is over appropriated?
In very general terms, yes, I understand that.
Do you understand that that these are some of those statutory tools?
I really don't know.
In your opinion, in that July 2018 timeframe, was the state engineer in a position to certify water availability from the Coyote Spring Valley for residential development?
I really don't know.
In your opinion, was the state engineer engaged in a bad faith effort to kill the master plan community as of that time?
No, that would not be my opinion.
At the beginning of your cross today, I asked you what the definition of bad faith meant. You said open and transparent. Or the opposite of being open and transparent, right?
Yes,
Would you agree with me that getting stakeholders into a public workshop process and providing options and inviting stakeholders' participation is open and transparent?
in general terms, yes.
If we can go back to the timeline, please, Lindsay, 553. I'm still on 005. Towards the bottom of your timeline, Mr. Naldi, you have 3 entries for August 2018. Do you see that?
I do.
And council showed you plaintiff's exhibit 3 from this time frame, which is, if we can pull that up, Lindsay. Plaintiff's exhibit 3. This was the email council showed to you that forms the foundation for your expert opinion that the state engineer acted in bad faith, correct?
Objection misstates testimony.
If it does, she can say so.
Would you repeat the question, please?
Yeah, earlier in your cross today, I asked you what the foundation of your opinion that the state engineer acted in bad faith is. Do you remember that?
I do.
And you said you looked at an email on your direct and formed that opinion, right?
Yes,
This is the email, right?
it is.
We can scroll down to 002. We can skip the earlier part of the email. It says, Jason, good afternoon. It's nice to see you on Tuesday. And Tracy Geeter is forwarding information to Jason King. Again, who you understand to be the state engineer at the time.
I do.
And the subject is Coyote Springs subdivisions. Do you see that?
I do.
We're on August 23rd, 2018, right?
We are.
We scroll up or just pan back out. Jason's response. Thanks for letting me know, Tracy. Were there any will serve letters accompanying them? Don't do anything, please, until I get back to you. You see that?
I do.
And scroll back out and back up to 001. Tracy's response to Jason's inquiry about the will serve letters. Do you see that there, bottom of the screen?
I do.
And what did Tracy tell Mr. King?
That no will serve letters were submitted accompanying the tentative maps.
She says, normally I receive an email from the Las Vegas Valley Water District and a hard copy of the letter within 3 days prior to someone named John signing the final map. I have attached the letters from LVVWD below. Do you see that?
I do.
And if we pan back out, you see the attachment indication on the top of the email?
I do.
Council didn't show you the attachments, did he?
No,
Would that have been information you'd wanted to see prior to forming your opinion on direct that the state engineer acted in bad faith?
I believe I know what those attachments are just by their titles. They're tentative maps.
Let's go to 3599 and 3600, please, Lindsay. We can just split screen them. They're one-page documents each. Have you seen these letters before?
Yes, I have.
We're in the August 2018 timeframe, right?
We are.
These are letters that have by email been forwarded to the state engineer, correct?
How would I know that?
Well, we just looked at a moment ago, the email exchange between state engineer Jason King and Tracy Geeter, where she says, here are the letters that we received.
Oh, I don't know that.
Okay. The information in both letters is identical, agreed, except for the subject line.
Yes,
And this relates to one of these letters relates to the large lot Coyote Springs Village A that we've been talking about in this case, correct?
it does.
Okay. And what does the Las Vegas Valley Water District, in its capacity as manager of the GID, say in its letter about water availability?
They say that they are unable to confirm the availability of water resources to support the recordation of the map.
And we looked at Mr. King's PowerPoint just a minute ago, right?
We did.
And at that time, there was a public workshop process going on, correct?
Yes,
And one of the goals was to maximize beneficial use of water, right?
yes,
The municipal water purveyor, however, is saying that they can't confirm water availability at this time, correct?
Correct?
At that point, was the state engineer acting in bad faith as it relates to CSI?
What action would you be referring to?
But your opinion is that state engineer, as it related to processing of CSI's subdivision maps, was acting in bad faith, correct?
A bad faith opinion had to do with on one day stating that they were intending to deny maps and several days later signing a settlement agreement stating that they would process the maps in good faith.
Understood. Can we scroll back out, Lindsay, to the email that precipitated this? That was Exhibit 3. The top paragraph of the email, and you can, if you can get the title and everything at the top there, please.